Hey, what up, y'all? I'm coming at y'all with some news. The judge dismissed Justin Baldoni's lawsuit against Blake Lively. Let's get into it.
As a mom, I feel like nap time just passes way too quickly and I never get any time for myself. But now with Publix,
Well, this is certainly a big update in the legal drama playing out between actors Blake Lively and Justin Baldoni. The judge has dismissed one of the complaints and laid out his reasoning in an order that is more than 100 pages long. We dug through the paperwork to bring you the very latest. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Okay, so breaking news out of the Southern District of New York on Monday. This is big. We just found out that the judge in the Justin Baldoni-Blake Lively dispute has officially thrown out Justin Baldoni's lawsuit, his amended complaint against Blake Lively, Ryan Reynolds, the New York Times, PR person Leslie Sloan. This is a motion to dismiss. It's the initial stage of trying to get a lawsuit through, and by all accounts, according to the judge, Justin Baldoni and his team, they failed. Here's what we're going to do. I just got the paperwork. I went through it like as fast as I could, 132 pages. I wanted to get something out to you as soon as humanly possible. So we're going to probably do a more in-depth breakdown of all this tomorrow. But here is exactly what you need to know real quick about why this lawsuit was thrown out. And remember the allegations here, right? Lively accused Baldoni of sexual harassment on the set of It Ends With Us. He's the director, the co-star. She also claimed that he and his team launched a smear campaign in the media and online against her. He fired back. He and his production company sued her, said that she took control of the movie, weaponized false allegations against him. He also sued the New York Times for publishing an article about the Lively complaint and the allegations, saying this was a one-sided hit piece. So you have this warring of lawsuits and claims, really abbreviated version of what's been going on the past few months. Okay, but now, the judge, Judge Louis J. Lyman, United States District Court Judge of the Southern District of New York Federal Court, he threw this out. Why did he throw out Justin Baldoni's lawsuit? Well, first he says there was no extortion. Quote, the Wayfarer parties cannot recover for Lively's alleged actions to steal creative control of the film from Baldoni and the Wayfarer parties. Regardless of the propriety of these actions, they do not constitute civil extortion under California law. The Wayfarer parties have not adequately alleged that Lively's threats were wrongful extortion rather than legally permissible hard bargaining or renegotiation of working conditions. Additionally, the Wayfarer parties have not shown that some of Lively's allegedly extortionate acts damaged them. Basically, by the way, in a motion to dismiss, the judge looks at all the allegations, takes them as true, and basically says, have you alleged sufficient facts, enough detail to warrant your claim? Is there enough to support it? And is there anything for a jury to decide? Or no, should it be dismissed based on law? So just keep that in mind. And by the way, if you recall, Baldoni had argued that civil extortion, the claim was based on one, allegations that Lively refused to return to production unless the Wayfarer parties agreed to her return to production demands. Remember, she said that she was suffering all these problems on set. Two, that Lively threatened to abandon her contractual obligation to promote the film or approve marketing materials unless the Wayfarer parties agreed to co-fund a screening of her version of the film. Three, that Lively threatened to boycott the premiere unless Baldoni was excluded. Four, that Lively and Reynolds threatened to attack Wayfarer in the press if it did not take the blame for problems during filming. And the court says the last set of allegations is not actionable because Wayfarer did not acquiesce in the threat and did not accept blame for problems during filming. And you know what the problem is here? Quote, Wayfarer did not lose anything, and Lively and Reynolds did not gain anything from the threat. And also, quote, the remaining allegations must be dismissed because the allegations regarding Lively's wrongful threats are conclusory and fail to support that the threats were wrongful. Furthermore, the Wayfarer parties have failed to plead that several key instances of alleged extortion caused actual monetary loss. For example, the judge says the Wayfarer parties focus significantly on the demand by Reynolds and Lively that the Wayfarer parties issue a self-destructive statement taking blame for Lively's press woes, or else the gloves would come off and they would attack the Wayfarer parties refused to issue any such statement. Accordingly, there was no reliance on the threat. The Wayfarer parties did not give up anything to Reynolds or Lively, and plaintiff did not sustain damages cognizable in a cause of action for duress. There's nothing there, basically. The Wayfair parties allege that in response to threats that Lively would stop acting in the film or breach her contractual obligations to promote it, they were forced to agree to the return to production demands. Again, they say this is extortion. That they had to give Lively greater control over the script, give her a producer credit, accept marginalization from the premiere. However, Wayfair does not plead sufficient facts to support an inference that these threats were legally wrongful. Lively did not threaten to physically harm the Wayfair parties or their property, nor did she threaten a false lawsuit. So basically what the court's saying is you're not talking about what she threatened to do, but what she threatened not to do, like not promoting the film or approving marketing materials, but there was nothing that you pled that said she even had an obligation and duty to do that. And by the way, a threat to breach a contract, that's not enough here for extortion. You need something more. Quote, courts consider a claim to involve economic duress only under limited circumstances, generally involving the wrongful exploitation of business exigencies to obtain disproportionate exchanges of value. There needs to be something more nefarious here. And also the court says this, the Wayfair parties allege that Lively's threat to boycott forced Baldoni to accept marginalization from the premiere. Remember, he was kind of like sent to the dungeon. Initially, the Wayfair parties do not allege that Lively had an obligation to them to attend the premiere, much less to attend the premiere with Baldoni. However, even if Lively had such an obligation, her suggested modification is directly related to the conditions of her own performance. There is no threat extrinsic and unrelated to the production of the film. There is also no disproportionate exchange of value, as the separation of the parties at the premiere is not alleged to have any financial implications. In other words, this is a bargaining thing. This is a leverage thing. This is a contract dispute. This is not extortion, the way I understand it. And really the point is, there's no harm, there's no damages for an extortion claim. Quote, the Wayfair parties have not alleged that Lively's editing or the eventual release of her cut of the film caused them actual monetary loss. Although the Wayfair parties preferred Lively to take less of a role in the production of the film, they do not allege that it made less money due to her editing or that her role resulted in costs to them. So the extortion one, thrown out, doesn't work. The judge also says the defamation claims, they need to be thrown out. Now, defamation, you have a false statement, it's published, you need to show actual malice when you deal with a public figure, meaning like you knew it was false when you made that statement, or you acted with reckless disregard for the truth, okay? Judge says defamation claims don't work here. Quote, the Wayfair parties bring defamation claims against all defendants. Allegedly defamatory statements or statements to the effect that 1. The Wayfair parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct toward Lively. And the Wayfair parties retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. The Wayfair parties allege that Lively, Sloan, and Reynolds engaged in a conspiracy to spread these defamatory narratives to the Times, other media outlets, and Baldoni's agency, WME, and that the Times committed defamation by publishing the same narratives. But the court says these allegations fail to state a defamation claim. The court says the Wayfair parties have not alleged that Lively is responsible for any statements other than the statements in her complaint, which are privileged, right? It's litigation privilege. The Wayfair parties have alleged that Reynolds and Sloan made additional statements accusing Baldoni of sexual misconduct, and that the Times made additional statements accusing the Wayfair parties of engaging in a smear campaign. But the Wayfair parties have not alleged that Reynolds, Sloan, or the Times would have seriously doubted these statements were true based on the information available to them, as is required for them to be liable for defamation. The Wayfair parties' claims of defamation against Lively, Sloan, and Reynolds are partly based on allegations that Lively and her team made false statements about the Wayfair parties to the Times. A fundamental obstacle to this claim is that the Wayfair parties do not plead and may not know exactly what, if anything, the Lively parties and the New York Times communicated to each other. Accordingly, the amended complaint fails to allege facts regarding who said what, if anything, to the New York Times and when. The act of providing the CRD complaint to the Times is not sufficient to constitute defamation, and that is because the complaint is protected by the fair reporting privilege. By the way, that protects news outlets from being sued when they report on certain matters of public concern, especially about public documents like lawsuits. Quote, The amended complaint insinuates that in addition to leaking the CRD complaint and providing the Times with related messages and emails, Lively, Reynolds, or the Sloan parties could have made other unspecified communications pressing their version of events. But the Wayfair parties allege no facts to support those insinuations. Allegations that Lively and her co-conspirators told the Times a false and damning story about an insidious PR sabotage operation, or that Lively spread a narrative that the Wayfair parties had responded to Lively's complaints about reported sexual harassment by plotting to destroy her reputation as a shadow smear campaign, are indistinguishable from the allegations that Lively leaked the CRD complaint. So in other words, it fails. There's nothing there. So you put that to the side, whatever's said in the complaint, right? That's protected. But also they make the allegation that, or the Wayfair parties make the allegation that separately, Sloan and Reynolds made outside defamatory statements, extra statements, that Baldoni was a sexual predator or committed sexual assault. But the court takes issue with this. Quote, specifically, the amended complaint alleges that Sloan told a Daily News reporter that Lively was sexually assaulted, but the court took issue with this. For example, with Reynolds, the allegation was that Reynolds told a WME executive and Baldoni's agent that Baldoni was a sexual predator. The court says the Wayfair parties have not alleged that these statements were made with actual malice, what I talked about before. For example, with Ryan Reynolds, quote, Reynolds was not present for any events during filming, and the amended complaint does not provide any reason he would have doubted Lively's version of events. In fact, several allegations in the complaint support that Reynolds believed that Baldoni engaged in sexual misconduct towards Lively during pre-production. Reynolds screamed at Baldoni after finding out that Baldoni had asked his trainer about Lively's weight. Reynolds then later yelled at Baldoni and demanded that he apologize for, quote, actions that had never happened in connection with the return to production demands, becoming further enraged when Baldoni refused to apologize. Given that the return to production demands concerned Baldoni's alleged inappropriate behavior towards Lively, the obvious inference is that Reynolds was yelling about Baldoni about this alleged behavior. So, in other words, Reynolds thought it was true. And then the court from there, again, this is a very, very abbreviated summary of what the court decided. The court also said that the Wayfair parties' additional claims also fail under this motion to dismiss, and that includes false light. False light, under California law, is an invasion of privacy by publicity that places the plaintiff in a false light in the public eye. And part of the reason that was thrown out is because of the weakness of the defamation claim. Now, the Wayfair parties, they also allege that Lively breached the implied covenant of good faith and fair dealing in the contract, quote, by which Lively agreed to perform as an actor in the film that ends with us by making threats, seizing creative control, and depriving the Wayfair parties of the opportunity to produce, edit, and market a film as contemplated by the contract. But, the court says, the Wayfair parties do not plead the terms of the relevant contract, which of the Wayfair parties it was with or when it was made. Wayfair parties allege that Lively and Reynolds intentionally interfered with the contract between Wayfair parties and WME, threatened to induce WME to drop Baldoni. But the Wayfair parties do not allege that they had contract with WME, the breach of which Reynolds knowingly induced, or any economic benefit that would have been realized from a prospective relationship with WME. Quote, they also failed to allege that WME was influenced by Reynolds' statements in any way, aside from conclusory statements that WME ceased performing, the relationship was disrupted, or the Wayfair parties were harmed. Other claims were dismissed by the judge too, like promissory fraud, breach of implied contract against the Times, considered them meritless. And this was really interesting. So sometimes a party will have an opportunity to amend a complaint, fix it in a way, and you can refile it. Here's what the court said, quote, the court will not grant leave to amend the majority of the Wayfair parties' claims because amendment would be futile. The dismissal of the claims does not rest on technical pleading defects, and the Wayfair parties have not made a showing that the complaint's defects can be cured. However, the court did say it will grant leave to amend the claims for tortious interference with contract and breach of implied contract. Wayfair parties failed to plead the specific details of any contract between Baldoni and WME, but suggest in their briefing that this defect is easily curable and that they will plead an oral or implied contract of which Reynolds was aware. Court says, given the allegations that Reynolds told WME to drop Baldoni, it cannot be said that repleading this claim on such terms would be futile. Similarly, The Wayfair parties assert that they are able to allege the details of Lively's contract with Wayfair, including that her right to consult and approve on the film be exercised in a reasonable manner. Without seeing the contract, the court cannot say that the amending the breach of implied covenant claim will be futile. So they have a little bit of an opening there. But this part's interesting too. Towards the end it says, Reynolds, Sloan, and Vision PR, her company, have moved for an award of attorney's fees and costs. And this is pursuant to different laws. Lively has moved for an award of attorney's fees, treble damages, punitive damages, punishment damages, right? The court denies the motions without prejudice to renewal in accordance with the ruling here. So there's denying it now, maybe because in the future. The court has ruled that the law applicable to the claims against Reynolds and Sloan cannot be determined absent further factual development. The court has not ruled on whether Lively's statements were privileged under California law. If defendants choose to renew their motions, they shall fully brief the impact of this opinion, if any, as well as the issues raised in prior briefing. And it ends, accordingly, the amended complaint must be dismissed in its entirety. However, the Wayfair parties have leave to amend their claims for breach of implied covenant and tortious interference with contract. Okay, really quick, there you go. Hopefully we get a chance to talk about it further. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.